I repeat, no one is to approach the dais. Chair, we are ready to begin.
Good morning. I am City Council Member Julie Menon, Chair of the Committee of Consumer and Worker Protection. I want to welcome all of you to today's hearing. First, I want to acknowledge my colleagues who are present, Councilmember Shulman, and I'll acknowledge additional colleagues as they join. Since the COVID-19 pandemic, the city's streetscape has been transformed by the proliferation of e-bikes, of mopeds, and other powered mobility devices. Although these devices have certainly expanded the ability for people to traverse the city, they've also driven exponential growth in deadly fires related to the lithium-ion batteries used to power these devices, as well as dangerous encounters between cyclists and pedestrians and these micro-mobility vehicles. The growth in e-bike and moped usage is fueled by a surge in demand for food delivery from third-party platforms. Large delivery zones and pay incentives to complete deliveries quickly have driven delivery workers to use e-bikes, e-scooters, and powered mobility devices instead of regular bicycles. The Council has passed legislation to provide better conditions for restaurants that use third-party platforms, to provide better working conditions for third-party delivery workers, and to facilitate the safe use of powered mobility devices by delivery workers. Today, we will hear a number of bills that relate to third-party food delivery and powered mobility devices. I'm just going to list and briefly describe these bills. First, proposed intro number 30A, sponsored by Councilmember Feliz, would establish safety standards for powered bicycles and powered mobility devices when used for food delivery services, grocery delivery services, and businesses using bicycles for commercial purposes. Mobility devices used for delivery could be provided by the company or by the delivery worker, but could not be provided at the food delivery worker's expense as a term of their employment. Second, Intro 972, sponsored by Councilmember Powers, would require all third-party food delivery services to verify that the mopeds used by their food delivery workers are properly registered prior to their use. Third, Intro 715, sponsored by Councilmember Shulman, would make third-party food delivery services responsible for ensuring that their food delivery workers operate e-bikes in accordance with the laws concerning the operation of bicycles on sidewalks and at intersections. Fourth, Intro 762, sponsored by Councilmember Salamanca, would establish exemptions for third-party delivery services from the limits on fees charged to restaurants. In 2021, this council passed a law to cap the fees third-party food delivery services could charge restaurants. That cap protects restaurants from exorbitant fees imposed by delivery services, which was critical during the pandemic and continues to be vital to this day. Intro 762 would amend this law by allowing third-party delivery services to increase their fees for restaurants that choose to pay more for additional services such as marketing in the app. We are hearing as well 3 bills introduced by Councilmember Abreu that were prompted by third-party apps' responses to the historic minimum pay legislation passed by the Council. After the minimum pay standard went into effect, some of the platforms changed their apps to make it harder for consumers to tip their workers. Platforms have also not been have been transparent with their workers about which method they are using to calculate pay. Intro 737 would establish gratuity standards for food delivery workers. Intro 738 would require third-party food delivery services that solicit gratuities to do so before or at the same time an online order is being placed. And lastly, Intro 859 would require third-party food delivery services and third-party courier services to disclose the pay method, display a running tally of a food delivery worker's working time, and provide food delivery service workers with an itemized pay statement for each pay period. I look forward to hearing from everyone here in terms of their testimony on these bills, and I will now turn it over to Councilmember Shulman to make her opening statement. Thank you.
Thank you, Chairman, and good morning. I'm proud to speak to you about Intro 715, This important legislation seeks to enhance the safety and accountability of food delivery companies, requiring third-party food delivery services to be responsible for the safe operation of electric food delivery bicycles. As you know, electric bicycles have become a crucial part of our food delivery infrastructure. However, this convenience must not come at the expense of public safety. Right now, delivery workers are essentially incentivized for speed, and their top priority is quickly completing their next delivery. This often results in driving recklessly, often putting the lives of pedestrians at risk, as well as compromising their own safety. Intro 715 specifically requires food delivery companies to ensure that their delivery workers operate electric bicycles in compliance with sections 19-176 and 19-195 of our city code, which govern bicycle use on sidewalks and at intersections. This bill mandates that these companies accept financial liability for any civil penalties resulting from violations of these sections while workers are engaged in deliveries. Additionally, the legislation provides an important safeguard for delivery workers and companies alike. Workers must notify their respective third-party delivery service of any fines within 10 days of issuance. In turn, it offers an affirmative defense for companies if they were not properly notified of a violation by their delivery worker. This bill is not just about assigning responsibility, it is about creating a safer environment for all New Yorkers, pedestrians, cyclists, and delivery workers. By holding companies accountable, we ensure that they take an active role in promoting safe riding practices and mitigating risks associated with the increasing rise of use of electric bicycles. I urge my fellow council members to support this legislation, recognizing that it strikes a necessary balance between fostering innovation in our food delivery sector and maintaining the safety and well-being of our community. Thank you, Chair.
Thank you very much. I'll call on additional council members for their opening statements as they join. So I'm now going to turn it over for the administration to testify. We'll be hearing testimony from Carlos Ortiz, Assistant Commissioner for External Affairs at DCWP, Elizabeth Wagoner, Deputy Commissioner of OLPS at DCWP, and Andrew Schwenk, Associate General Counsel. I'm going to turn it over to Committee Counsel to administer the affirmation.
Please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and to respond honestly to council member questions?
I do.
You may begin.
Thank you. Good morning, Chair Menon and Councilmember Schulman, members of the Committee on Consumer and Worker Protection. My name is Carlos Ortiz, and I am joined by my colleagues Elizabeth Wagner and Andrew Schwenk. Thank you for the opportunity to testify today on instructions 30-A, 715, 737, 738, 762, 859, and 972 relating to delivery worker gratuities and pay transparency, delivery fee caps, and ensuring app responsibility with respect to street safety. Since the start of the administration, DCWP has helped deliver more than $600 million into the pockets of New Yorkers. We provide fundamental consumer and worker protections and financial empowerment programming to New Yorkers. We strive to ensure that consumers who have been deceived or exploited have recourse, that workers have a passionate defender of their rights, and that all New Yorkers have the support they need to improve their financial health. Just over a year ago, Mayor Adams announced the nation's first-of-its-kind minimum pay rate for app-based restaurant delivery workers, the most significant advancement of workers' rights in New York City in the 21st century. Ahead of implementation, DCWP conducted a comprehensive study of the industry, considered thousands of comments received from food delivery workers, apps, advocates, restaurants, researchers, elected officials, and members of the public when studying this historic rate. We continue to collaborate closely with key advocates and stakeholders across the space. Delivery workers are essential workers for New York City. They have braved harsh weather conditions, harmful wildfire smoke, and even the pandemic to ensure New Yorkers are fed. Thanks to their incredible organizing and determination, tens of thousands of workers have now seen their weekly pay double, with their combined annual earnings on track to increase by over $775 million this year. This administration will continue to stand shoulder to shoulder with delivery workers and ensure their fundamental rights to fair and dignified pay are protected. Moving to today's bills, I would like to start off by commending the Council, and specifically Councilmember Abreu, for recognizing a key issue that delivery workers are facing since certain major apps made changes to make it harder to tip delivery workers. We strongly support Introduction 737 and 738, which would require third-party food delivery service apps to give customers the option to leave a gratuity during an order transaction and include a suggested gratuity option of 10%. Before apps began paying the minimum pay rate in early December 2023, they generally made tipping a delivery worker a simple process, giving consumers the option to tip during the order transaction. However, After they began paying the minimum pay rate, 2 of the 3 most used apps removed the option for a consumer to add a tip when placing an order. As a result, delivery workers' tips received on those apps have decreased dramatically by $85 million in total since the apps changed their tipping options. Conversely, other apps, including one of the 3 most used apps, continue to allow tipping when placing an order, and while the average tips on orders placed on those apps did decrease slightly, workers are receiving substantially higher tips on those apps. To us, this speaks to the fact that New Yorkers, when given an option, recognize the incredibly difficult jobs these workers perform and choose to tip them. As we understand the intent of these bills, they will require apps to restore to consumers the option they previously had to tip workers when placing an order. We recommend changes to the bill text to make clear that apps must offer consumers these tipping options. We are eager to engage in the legislative process as soon as possible to finalize this legislation to best support delivery workers in our city. Instruction 859 would require third-party food delivery services and third-party courier services to provide delivery workers with sufficient information on their pay calculations. We are fully supportive of clear pay transparency for workers as well as this legislation. The apps are required to report aggregate monthly pay information to DCWP so that we can monitor compliance, but apps have not been transparent with workers themselves about their pay calculations. Workers should have full information about how their pay is calculated so they are not left with questions about an app's pay structure. We believe this legislation will help ensure this happens and will make it easier for advocates to educate workers on the minimum pay rate. Councilmember Salamanca's bill, Instruction 762, would amend the current fee caps for third-party food delivery services. The caps on fees that delivery apps can charge restaurants were first created by the Council during the COVID-19 pandemic and were later made permanent under Local Law 103 of 2021. Currently, delivery apps can only charge a restaurant a total of 23% of an order in fees, broken down as follows: up to 15% for delivery fees, up to 3% for transaction fees, and up to 5% for other fees. Instruction 762 would increase the cap on other fees from 5% to 25%, potentially allowing delivery apps to charge restaurants up to 43% of an order in fees. As an enforcement agency, DCWP will enforce the fee caps at the limits mandated by local law, and I would also like to note that the current fee caps are subject to ongoing litigation. Lastly, Instruction 715 would require food delivery companies to be responsible for ensuring that their workers who use micromobility devices follow appropriate traffic laws. Instruction 30-A, which the Department of Transportation previously testified on in January, would establish new requirements for businesses using a bicycle for commercial purposes, such as third-party food delivery, grocery delivery, and courier services. This includes the requirement that any powered mobility device, such as an e-bike, used by a worker on behalf of such businesses meet certain safety certification standards. Instruction 972 would require third-party food delivery services to verify the registration of mopeds used by delivery workers. The administration is committed to ensuring that micromobility devices are used safely on our streets. Along with our colleagues at DOT, we are working on a comprehensive policy review of how micromobility delivery is regulated in New York City. We believe it is vital to address the current situation holistically with an approach that tackles both street safety priorities and workers' rights. Each of these 3 bills addresses issues that will inform vital components of that unified approach. A key point that DOT and DCWP would like to stress is that delivery apps have a responsibility to ensure that workers have access to and use safe equipment, and that workers are not compelled into unsafe riding practices because of dangerous demands made of them by those same apps. For example, we have heard reports from workers that apps may penalize or deactivate them if they do not deliver orders within a delivery app's mandated time frame, despite there being obstacles such as traffic, restaurant delays, or route issues that are outside of a worker's control. The perverse incentives flowing from apps' unrealistic delivery times could be a major contributing factor to some of the unsafe practices we are observing in our city today. And another example I'd like to share is when workers receive app orders while in transit, and if they don't respond to these app orders, they are penalized subsequently. Ultimately, workers are compelled into these situations because the deactivation can be financially devastating for them and their families. One final point underscores DOT and DCWP's holistic approach. Instruction 30A would bring street and device safety protections to grocery delivery workers, in addition to restaurant delivery workers. This is an important step in the right direction from a street safety perspective, but it should go even further for the issues DCWP enforces and has responsibility for. As discussed in the administration's blueprint for economic recovery, workers who deliver all types of consumer goods would benefit significantly from minimum pay and other protections. So, as we work on all this legislation together, the administration wants to ensure it addresses the root causes of unsafe riding, that it does not have unintended consequences on workers, and that each bill works in concert to develop better policy outcomes for New Yorkers. Thank you for the opportunity to testify on these bills and for your collaboration with our efforts to support working New Yorkers. We look forward to answering any questions you may have.
Thank you very much. I'm now going to turn it over to Councilmember Salamanca for his opening statement.
Thank you, Madam Chair, and good morning to all. And good morning to you, Mr. Panel. I would like to speak on my bill, Intro 762. Intro 762 is a comprised solution that is the result of months of collaboration with New York City restaurants, the council, food delivery platforms, and other key stakeholders in New York City's delivery ecosystem. Intro 762 offers restaurants more flexibility to opt into supplemental marketing and promotional plans, which are critical for small businesses trying to compete against national chains. This bill ensures fairness and transparency in the industry and protects restaurants from exploitation while helping them attract new customers on their terms. Intro 762 protects businesses by prohibiting third-party apps from purchasing restaurant names for advertising purposes without consent, while also guaranteeing restaurants' ability to set prices for items ordered through third-party apps compared to in-person or direct orders. A benefit to restaurants, Intro 762 gives restaurants an option to include physical marketing materials with orders, enhancing in-house advertising efforts in the process. Furthermore, Intro 762 allows restaurants greater flexibility to obtain restaurant-tailored marketing services provided by third-party platforms to expand outreach to new customer bases. Intro 762 also protects consumers by maintaining both the 15% cap on delivery fees, as well as the 3% cap on credit card processing fees. A common misconception is that Intro 762 guarantees that all restaurants will be listed and discoverable on third-party platforms, regardless of whether they opt into additional marketing services. Lastly, this bill creates a level of government oversight by requiring the Department of Consumer Affairs and Worker Protection to conduct regular assessments of the industry to ensure rules and regulations are being followed. These measures are crucial for balancing the future success of all members of the delivery ecosystem: consumers, carriers, restaurants, and delivery platforms. This proposal strengthens from its previous version of Intro 813 with input from the stakeholders, which has widespread support from small and independent restaurants throughout the city and will provide some of the strongest restaurant protections in the country. I thank my colleagues who have already co-sponsored Intro 762 and look forward to working with the industry stakeholders to pass this piece of important legislation. Thank you, Madam Chair.
Thank you. And I'll now turn it over to Councilmember Abreu for his opening statement.
Good morning. Thank you, Chair. Thank you to the admin. Sorry I'm a little late. Just came back from a school graduation, but on my way here, I was paying attention to the testimony, and I'm very excited to see that the admin doesn't only support the intent of the bill, but you strongly support the bill. And every time when you find all your bills to be strongly supported by the administration, we're sending a message. And so we're sending a message that we're standing up for our deliveristas. We're sending a message that we're standing up for working class families. Intro 738 would require that the tipping option be displayed at checkout, not after consumers have already received their orders, they close down the apps, and are chowing down. In response to their minimum wage agreement with deliveristas, delivery apps have retaliated by hiding the tip menu for consumers, knowing that deliveristas will lose out on meaningful earnings, and they have. Uber and DoorDash removed it, but Grubhub kept it. And as the testimony today by our Deputy Commissioner Ortiz, those apps that have kept the tipping option at checkout, like Grubhub, earnings and tips have been mostly on par with the tips that we have seen before the minimum wage went into effect. But for those apps that have removed the tipping at checkout, we're talking about $85 million. That is insanity. And that difference would make the difference for our working class families. And that's why we're here today. Intro 737 would require that the suggested minimum tip be set at 10%. It would only be suggested, is what I will say. $20 order, a $2 tip, I mean, come on now. And also, if you do not want to provide those $2 on a $20 order, when people are driving their orders during blizzard conditions or during times at which there's scorching weather like this heat wave today, then it is your option to not tip. but we want to provide that option because makes it a lot more fair. And this comes at no cost to the app or to the apps or the users, but it contributes to better consumer habits. Intro 857 would require third-party food delivery services and third-party courier services to provide food delivery workers with standard information relating to their pay calculations. A crazy idea. We want to know how people's pay is getting calculated. We want to know their active time worked. For God's sake, is this something that we have to fight for through legislation? Any worker in this city should know their active time worked. They should know how their pay is getting calculated. And the fact that we're fighting these apps on this is insanity to me. It's insanity. Thank you, Chair.
Thank you, Council Member. Okay, we're going to go into questions for the administration. So the administration had announced a number of months ago that you would be creating an Office of Sustainable Delivery. What is the status of that office?
Thank you for the question, Chair Menon. As I mentioned in my testimony, we've been currently engaging with DOT to develop this comprehensive policy review. I also know that the Mayor's Office and the Deputy Mayor of Operations have been working closely with central staff as well to identify the particular policies that this new body will work through, particularly as it relates to street safety priorities and workers' rights. I expect that we'll be working on that over the summer, and then we can have actual content for the council to look at in September, early fall.
Okay, I'm going to really urge the administration to move as expeditiously as possible on that. We really need that because right now we're dealing with an alphabet soup of agencies on this, and there's no sort of one entity that has control over the myriad issues. So we really want to see that move forward as quickly as possible. What specific measures will be put in place to prevent e-bikes and mopeds from speeding on sidewalks and endangering pedestrians?
Well, I think something I really like to highlight is the fact that apps bear a certain responsibility here for promoting certain practices, and we need to make sure that any approach identifies their accountability in this. And what I really want to talk about then is arbitrary deactivations, unrealistic delivery times, contacting workers while they're in transit. I think these are some of the issues that we really need to address in a comprehensive policy review to ensure that workers are not compelled into unsafe practices. Additionally, I think I'd also just want to note again that we were certainly supportive of expanding the minimum pay rate to other industries that engage in delivery for independent contractors. And I think those pieces from a DOT and DCB perspective would be really important.
Okay, a number of questions on the legislation. I want to start with Intro 762. So I understand, obviously, there's active litigation, but what is the administration's position on Intro 762?
Thank you, Chair. I think on the advice of the Law Department, I can't comment on for a position of the legislation. There is ongoing litigation. I can provide a status update of that if that's helpful. Or let me just say that the city had a motion to dismiss the litigation, but that was denied. And currently, we're in a process of discovery and depositions, and hence why I can't provide further comment. I do want to take, I think Councilmember Salamanca's point is well taken. It's, as in the hearing last session and today's hearing, I think it's important to hear from stakeholders in this space. And I really would be encouraged to hear from restaurants, apps, delivery workers, all about the impacts of the fee cap.
Look, I understand there's active litigation, but I still think the administration can comment on the legislation, which is not subject to the litigation.
I think for us, the litigation is still outstanding. For us, we will enforce the fee caps wherever they're set. But in terms of resolving the litigation, I think that's the key question.
Okay, how many complaints has the administration received related to fee caps?
Thank you, Council Member. We've received one single complaint about the fee caps since the law was put into place. That was a complaint received in 2022. It was successfully mediated by our office. It was a restaurant who alleged that one of the delivery apps had violated the credit card transaction fee cap. And through our mediation efforts, we were able to secure a return of over $500 to the restaurant to make that restaurant whole for the overcharge on the credit card transaction fee.
And how many violations have been issued?
No violations.
No violations, okay. And in terms of, if you're concerned that increased fees could lead to restaurants losing access to their customers, how do you plan to mitigate the risk of reduced revenue for these businesses?
I don't think that's a concern that we've articulated, although if restaurants do feel that's a concern, I think this hearing is a perfect setting for them to share. Ultimately, I think for us, no matter where the fee caps are at, we'll make sure to communicate that proactively to restaurants and continue the engagement we've had with the app industry too, to ensure compliance with local laws.
And other than amending the fee cap, which is obviously the subject of Intro 762, is there any additional support either your agency or SBS will be providing to restaurants to help them succeed?
Well, I think I guess going into the other parts of our agency's work, we do have a lot of programming that supports small businesses in our city. I'd like to think of, for example, about Mayor Adams' expansion of our free tax prep program for self-employed New Yorkers. SBS is a key partner in that, and I know we always work to help educate small businesses on their responsibilities, and we'll continue doing that good work.
Moving on to Intro 737, 738, 859, you indicated, as Councilmember Abreu noted, that you strongly support this legislation in terms of 737. How many complaints have you received regarding restrictions on third-party food delivery service conduct?
Well, I think with respect to tipping in particular, we received 8 complaints for delivery workers related to tipping that's currently, as it relates to what's currently in local law. I will say we have received a lot of complaints from folks about the changes that happen to the interfaces, albeit none of that is necessarily illegal right now, although this legislation would change that. So we don't have the clear numbers on that, but I think it's something that workers are talking about a lot and definitely have complaints about.
And how many violations have you issued on that subject?
We have not issued violations on the tipping subject because the issues that are present in this bill, it's not currently illegal to change the tipping interface.
Okay. And how many complaints have you received regarding the sale, lease, and rental of powered bicycles, powered mobility devices, and storage batteries for such devices?
This is with respect to Local Law 39, correct? Mm-hmm. So we've received over 40 complaints on those with respect to Local Law 39. I think since that law took effect in September of 2023, we've conducted close to 600 inspections, issued violations to close to 200 brick and mortars, as well as 25 online retailers as well.
And have you encountered challenges in terms of enforcing this local law?
No, I think this is the type of work that is really a bread and butter for our consumer protection team. Being able to identify and proactively inspect locations, it was certainly a high priority for us when this law was in place, and additionally why we recommended so many amendments earlier this year to increase penalties, to provide the city with sealing authority for recidivist behavior. So we're looking forward to those amendments taking effect in September for us.
And can you provide an update on the city's trade-in program that was established pursuant to Local Law 131?
Yes, Chair. So that trade-in program is being managed by DOT. My understanding is they'll be promulgating rules in July, and they're looking to have registrants by the end of the year for that program.
Okay, wonderful. I'm now going to turn it over to my colleagues for questions. First of all, Councilmember Salamanca? No. Okay, Councilmember Abreu.
Thank you, Chair. This is a question to admin. Are there any tweaks to the existing bills you would like to make?
So I think with respect to both of the bills concerning tipping, we want to make sure to close a loophole we see in the current text that would allow apps to continue to have the option to offer a tipping interface or not in the order process. We think it should be mandatory that apps offer the tipping interface before the order is placed.
Thank you. Very helpful. DoorDash recently sent a communication to its workers stating that my bills, Intro 738 and 737, would decrease the amount of orders that consumers make, thereby harming both restaurants and deliveristas. This is confusing to me, considering tipping is completely optional, whereas the New York City surcharge that the apps responded with are not optional. They were willing to push that cost onto consumers and restaurants as part of their business model, and then remove tipping option at checkout to artificially and disingenuously keep the total cost down. Putting that aside, however, can you please speak to the data on the volume of orders apps have reported to the agency, and what differences were reported in terms of monthly deliveries made pre and post minimum wage taking effect?
Yes, I'm happy to. So we, you know, we receive monthly reporting from the apps on a variety of topics that allow us to monitor compliance. That includes reporting on the total number of deliveries. And so we can compare the first quarter of 2023 to the first quarter of 2024. In other words, when there was no minimum pay rate, then compared to the first quarter of 2024 when there was a minimum pay rate. And what we see is an increase of 8%.
There's an increase.
That's right.
Not a decrease, or not even the same level, it's an increase.
That's right.
So is it fair to say that this notion that tipping at checkout would reduce would reduce the orders?
We see no reason to believe that that would occur if these bills were.
And that's an argument being made by big tech, just so you're aware. Okay. Then there was the argument that tipping, which was removing the tipping at checkout, which was done in retaliation, that would impact that's something that they're bearing as a cost. Is it your understanding that the service charge is being done to fund the minimum wage?
That may be the case. What we're seeing in the data is that customers are actually paying less for delivery now under the minimum pay rate than they were previously, in part because of these tipping changes.
Councilman, I think just to piggyback on that a bit, I really do appreciate the graph that we've been able to put in our testimony. I think that really showcases the issue that your bills are going after. And essentially that New Yorkers, when given an option, do choose to tip. Again, this is all about options. And ultimately, you know, I think the minimum pay rate has been a major success. Pay is up, deliveries are up. Tipping is still a component of take-home pay, and we're just saying that let's make sure New Yorkers have an option here. So thank you very much for these bills.
And just so folks are also aware that just because deliveristas got minimum wage, they didn't get everything under the sun. In fact, they're not getting minimum wage necessarily per hour. There was a story, and I've said this last night on Errol Lewis. There was a story of a deliverista who worked from 6 a.m. to 3 p.m., worked 8 hours, and only made $63. Because the minimum wage only applies to active time worked, from the moment you pick up the delivery to the moment you drop it off. But when you're doing call time, those resources aren't necessarily pulled evenly, and $63 for 8 hours is poverty wages. If they had in fact been making minimum wage per hour, they would have made nearly 3 times the amount, somewhere around 180 something. That is what we're up against right now. And there's a lot of disingenuous arguments being made, and our job, I'm so grateful that the council and the administration is united on this issue. Thank you.
Wonderful. Councilmember Salamanca, some questions?
Yeah, thank you, Madam Chair. I will be brief. I understand that you're limited on what you can answer, but is the administration supportive of the revised bill now from 813 to 762?
I apologize, Councilmember Salamanca. Just on the advice of the Law Department, because of the litigation that the administration and the council are a party to, I really can't comment on the legislation today, although I am thankful for this setting, as we've had many settings over the past few years to discuss the fee caps and for stakeholders to provide feedback to.
An idea when the litigation will be completed?
It's hard to predict. I did mention earlier that we did file a motion to dismiss, but it was denied. And right now we're in, I think, a process of discovery and depositions of key folks. So I don't really have a timeline I can share on specifics there.
Yeah. I just want to point out certain keys on this new bill. You know, under the current law, the max that can be charged at restaurants is approximately 23%. That's broken down by 15% for delivery, 5% for marketing, and about 3% for order processing. Now, Intro 762 would merely raise the cap on fees for marketing services for those restaurants who desire to give their promo a boost. With that, I have no further questions since I understand you're limited on what you can answer on this bill. Thank you, Madam Chair.
Thank you, Councilmember. I'll now turn it over to Councilmember Feliz.
Thank you. Thank you so much, Chair Menon, for this hearing, and also to all my colleagues who have bills before this committee today. So a few questions on Intro 30A. What's the administration's position on this bill?
Thank you, Councilmember Feliz. I think our position has not changed significantly from what DOT testified to in January. I believe that, or we believe that apps bear responsibility here to ensure that workers have access to safe devices, are using safe devices, that they're not being compelled into unsafe riding practices. I think for us at DCBP, we're looking to work very closely with our colleagues at DOT to make sure we're developing a comprehensive policy to address street safety priorities, such as your bill, as well as worker rights components for us.
Thank you. And what are ways that the bill could be properly implemented? The bill would, of course, require that the apps provide an e-bike to workers, UL certified e-bike to workers who don't have one. I know we're basically inventing the wheel. We would be the first in the entire country to create an important program like that. So what are ways that we could get this properly implemented? What are systems that still need some work so that we could be able to get this right?
Well, I know in January, DOT mentioned as a part of their implementation that they would consider aspects such as safe dispatch requirements, ensuring that workers are dispatched on safe devices, compliance planning and things like that the apps could report to them. I think these are some of the key components that DOT would work through, and we would certainly, through our experience in our own delivery side of the space, would be informative of that too.
Okay. Is there any tweaks that you would recommend to for the bill, or would you say, as written, we could move it forward, vote, and pass it?
Well, I would say one thing that I think is important from the administration perspective. I mean, I think there are a number of bills, for example, on today's hearing that have to deal with street safety issues, worker rights issues. I think for us, it's critical that these pieces all work together in a unified approach. Not even just thinking even definitionally to make sure things are aligned, make sure that just make sure that all these bills are working together. I've certainly had experiences in other spaces where things can happen piecemeal, and I don't think that's what anybody wants here. And so our goal is to make sure that we have close coordination and collaboration with the council. I know the mayor's office, the deputy mayor of operations, have been working closely with central staff on these issues. So I'm looking forward to developing this over the summer and having some content for the council into the early fall.
Perfect. Thank you so much. And we look forward to continued conversations about this bill just to make sure we get it right. We're, again, inventing the wheel. It requires a lot of pieces, getting them properly just to make sure that we could get this right on the first round. And also just want to say we have a major problem. Want to briefly go over some of the fire-related numbers. Last year, for numbers related from January through end of May, last year we had 97 fires due to e-bikes. This year we've made a little bit of progress, but not enough. 89 fires, just 8 less fires compared to last year. Also injuries, 65 last year from, again, January through end of May versus 44. We've made some progress, but clearly it is not enough. And we need everybody to step up, including the companies. The companies have their biggest market in the city of New York, and it's unacceptable that on a problem as serious as this one, they continue to just look away and hope that somebody else resolves the challenge. So look forward to getting this bill to the finish line. I would say this bill is obviously not perfect yet, and I look forward to listening from the apps just to make sure that whatever tweaks need to be made are made. But again, we have a major problem, a problem related to safety of workers, and we need the companies to step up. It is unacceptable that the companies, whether it's but it's unacceptable that companies with their largest market, they just, again, continue to just look away and hope that somebody else resolves the problem. So look forward to working with everyone, every single company, and every single stakeholder, get feedback about different ways of getting this bill right, so that once and for all we could finally resolve this problem. But yeah, I want to thank all of you for working with all of us to craft this bill and resolve this issue. Thank you so much.
Councilmember Abreu.
Thank you again, Chair. With regard to pay transparency, can you speak to what delivery workers are currently able to see on their pay stub?
So right now, the apps have a great deal of discretion in terms of what information they give workers about their pay. And so the interface is going to vary depending on the app. But what we are hearing from workers is that they are not getting details about how elements of their pay are calculated, so that they're unable to understand or predict kind of what they're going to receive. And so the concept behind the bill is a good one to require apps to give workers more information about the pay calculation.
And to your knowledge, are workers, or at least from based on what you're hearing, are workers able to see a breakdown of their active time versus their on-call time? Have you heard any issues about that?
At some apps, that is the case, but in terms of how that allocation of on-call time translates to dollars, that is, at some apps at least, opaque to workers.
You know, you can name the apps. I mean, tell me which ones. Is there any way currently for workers to check for wage theft or otherwise verify the number on the, sorry, let me start again. Is there any way currently for workers to check for wage theft or otherwise verify the number on their pay stub matches what they were expecting for the week?
So yes, their workers can file a complaint with DCWP at nyc.gov/workers or by calling 311. And through a combination of information that the worker has about their individual trip time and the reporting we're getting from the apps, we are able to check and verify that for most people. There are some open investigations, but for the most part, we are able to help workers with that.
Let me ask you another question. If an app tells deliveristas, if this bill moves forward and you support this bill, this will likely result in you losing your tipping, would you consider that as retaliation?
I think I think I cannot speak to the app's motivations behind making that change.
But if someone is engaging in the activity of supporting this bill, supporting our bills, and then there's a threat that says your tipping option may be removed if these bills pass, would that be considered retaliation? Because if not, then that's something we should look into.
Certainly a threat to exercise, a threat against a worker for exercising protected rights under the law is retaliation.
And would you consider supporting these bills protected activity? Supporting council legislation protected activity?
That's a complicated legal question. I'd have to think about that one.
All right, thank you.
Okay, thank you very much. I want to thank the administration for, Councilmember Salamanca.
Just have one question in terms of the litigation. Should the city lose this lawsuit, how much would it cost the city?
I don't think we have any sort of estimate of that figure here, and I think we'd be happy to put you in touch with law department attorneys who might be able to answer more questions about the current state of the litigation.
All right, I've heard a number of about it will cost the city about $1 billion.
Yeah, we couldn't possibly estimate right now, at this state of play.
Okay, all right, thank you.
Councilmember Filez.
Thank you so much. A few more questions. The next round of questions on Intro 972, 2024, by Councilmember Powers, which would require that the third-party apps verify licensing for those that are doing deliveries with mopeds. I would state the same points that I mentioned earlier on in the context of mopeds. Unacceptable that we have a large amount of individuals engaging in deliveries with mopeds, and the companies turning a blind eye on those that are engaging in deliveries without licensing. A big issue. When people don't use licenses, we see what I've seen, and you only need to spend a minute in the streets of New York City to see it, is people engage in recklessness, whether it's running red lights, so much more, putting everybody at risk, including themselves. So I think Intro 972 is very important bill to make sure that the companies are playing a role in helping us resolve that issue, rather than, again, saying, hopefully somebody else can resolve it. Quick question. So the bill will require that the apps verify that the mopeds are licensed. What are ways that we've thought about, ways that they could potentially do that? Obviously, they have a large fleet, different companies, and some workers are working for different companies at the same time, if I'm correct.
Thank you, Councilmember. I think, well, one, I want to make sure I want to be clear for the administration's perspective that street safety is paramount. I think we all bear responsibility to make sure we're following appropriate traffic laws and rules for the safety of our friends and neighbors and family. But I do think you've hit the nail on the head that there are certain aspects of this that are the responsibility too of apps that are engaging tens of thousands of workers throughout our city. One, for example, I think thinking about my work with my colleagues at DOT, for example, and they're standing up with the Revel scooter program. They have had aspects of confirming that folks were wearing helmets, confirming the identity of the riders on the Revel scooters. That's a case I've heard an example of that I'm sure DOT would delve in further for. But again, I think we are certainly, as an administration and I'm sure as a council, we are having to develop these robust policy responses because of these dynamics that have happened in our streets that are certainly dynamics of unsafe practices that are being driven from app companies.
All right, thank you so much.
Okay, any more questions? Going once, going twice? Okay, thank you to the administration. We really appreciate your testimony today.
Thank you very much, Chair.
We will move right into the public comment period because we are eager to hear from the public. So I'm now going to open the hearing for public testimony. I want to remind members of the public that this is a formal government proceeding and that decorum should be observed at all times. As such, members of the public shall remain silent at all times. The witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but they may submit transcripts of such recordings to the Sergeant at Arms for inclusion in the hearing record. If you wish to speak at today's hearing, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When recognized, you'll have 2 minutes to speak on today's hearing topic, which is Intro 30-A, 715, 737, 738, 762, 859, and 972. If you have a written statement or additional written testimony that you wish to submit for the record, please provide a copy of that with the Sergeant at Arms. You may also email written testimony to testimony@council.nyc.gov within 72 hours of this hearing. Audio and video recordings will not be accepted. I will now call the first panel. The first panel is Claudia Enriquez from the New York City Comptroller's Office. Yeah, just put the red light on. Thank you.
Hello. Okay. Good morning. My name is Claudia Enriquez. I'm the Director of Worker Rights in the Bureau of Labor Law at the Office of the New York City Comptroller Brad Lander. And as you all know, when Comptroller Lander was a member of this council, he spearheaded the labor protections for delivery workers. Many of those standards are in place today, and this set of issues is very important to him. At the Bureau of Labor Law, our mission is to protect vulnerable workers from exploitation, and that is why we are here today. Comptroller Lander strongly supports Intro 737 and 738, which establish standards around the solicitation of gratuities for app-based delivery workers. As my colleagues at the Department of Consumer and Worker Protection already testified, it's well documented that after the minimum pay law went into effect, certain platforms changed their tipping structures so that customers could only tip after the order was placed or delivered. This resulted in lower overall tips to workers on those platforms. And so we support legislation that would regulate this. We did want to flag an issue with the way that the language is drafted. Both bills state that where tipping is solicited or if tipping is solicited, then these requirements would apply. And we encourage the council to be thoughtful about that wording so that it doesn't inadvertently provide a loophole for the apps to remove the tipping option altogether, and which we understand has already been threatened. Comptroller Lander also supports Intro 859, which would promote pay transparency. Workers have the right to this information, just like workers in other industries have access to their itemized paychecks and time records. Some of the bills before the council address traffic safety, and workers, we support that workers be protected, that they are not incentivized to engage in unsafe acts, such as running red lights because of the time pressures. I see that I'm almost out of time. The remainder of my comments will have been submitted in writing.
Great, thank you very much. Thank you. Okay, I'm now going to call the next panel. Haley Prim, Joshua Bosian, Cassandra Perez Desir, and Brian Lozano, please come up. Thank you. Okay, please begin.
Good morning. My name is Joshua. Are we still in the morning? Good morning. My name is Josh Bosian. I'm the head of government affairs for Grubhub here in New York City. I'd like to thank Chair Menon and the members of the committee for the opportunity to testify today in support of Intro 762, the Fair Competition for Restaurants Act, as well as a range of issues facing delivery couriers in our city. While my testimony today focuses on 762, the Fair Competition for Restaurants Act, and the need to provide New York's independent restaurants with long overdue relief from caps on marketing services, I'd like to thank the council and recognize the important work being done to support delivery couriers. Grubhub continues to be a willing partner in these efforts, and we see reasonable paths forward on a number of these proposals being heard here today. We look forward to continuing those conversations. Intro 762, the Fair Competition for Restaurants Act, is the result of nearly 2 years of collaboration and compromise. So it's no surprise to see that it has broad support from multiple borough chambers of commerce, from restaurant groups like the New York State Latino Bar and Restaurant Association, and from countless restaurant owners themselves from across the city, many of whom are here today to voice their support. Together, we've made the Fair Competition for Restaurants Act, Intro 762, the strongest bill of its kind in the country. This amendment will give New York's independent restaurants a fighting chance against the big national brands and their massive advertising budgets. It affords them the choice, let me repeat that, the choice to take advantage of tools to expand their customer base, reward loyalty, and increase orders. At the same time, it includes a number of new safeguards to ensure restaurants' interests are protected. This bill is a win-win-win for restaurants, for diners, and for the couriers who deliver their orders. I'd like to thank the chair and the committee for holding this hearing today and to discuss the Fair Competition for Restaurants Act, Intro 762, and the whole host of issues facing our industry. By passing this amendment, we can ensure that New York's small, independent restaurants are afforded a level playing field and the right to compete fairly. Let's take this crucial step together to strengthen our delivery ecosystem for the benefit of all New Yorkers. Thank you.
Good morning, Haley Prim, Senior Policy Manager at Uber. Good morning, Chair and members of the committee. We will submit written testimony detailing our concerns regarding Intros 715, 30A, Intro 972, and our support for Intro 762. I will focus my 2 minutes on Councilmember Abreu's tipping and pay calculation bills, which we oppose in current form, but welcome any conversation on any of the legislation listed on the agenda. First, some facts on tipping. Delivery workers who use Uber Eats currently make a minimum of $19.56 per hour plus tips. Uber Eats customers have the option to tip their delivery provider on every single order, and since January 1, they've tipped in total more than $25 million, or on average $1 million each week. Third-party food delivery workers are the only app-based workers with mandated minimum pay in the city, and by law they receive more information and have more choice than any app-based delivery worker in the city. The DCWP's November 2022 report stated that the new pay standard would ensure that delivery workers would no longer be so reliant on tips, and predicted that tipping may be reduced or eliminated in light of workers' higher pay. When the pay standard went into effect, Uber Eats did not take away the option for consumers to tip. The only thing that changed was when consumers would be able to tip, and that decision was made in part to help comply with requirements from this council's previous legislation. The council is also considering a bill that would create new requirements related to workers' pay calculations. However, components of this bill are technically impossible to implement. Other components would likely lead to more questions and confusion from workers, and others contradict pieces of the pay standard. Uber supports transparency. Workers already receive pay statements every week, which provide detailed information related to earnings, gratuities, total trips, and more. Just this past week, we launched an addendum to pay statements, which provides more information about the expenses, paid sick leave, and workers' compensation components that the DCWP explicitly considered when calculating the pay standard. We welcome continued conversation with the council on these bills and others being heard today. Thank you.
Good morning, Chair, members of the committee. I'm Cassandra Perez-Desir on behalf of DoorDash. New York City's current price controls on restaurant delivery services are outdated, extreme, and risk causing further harm to restaurants, dashers, and consumers. Intro 762 is a common sense solution that guarantees restaurants have low-cost delivery options. It addresses concerns raised by the council and stakeholders alike, and the council should advance this bill so restaurants have every option available to help them recover and flourish. However, the other bills under consideration today take a one-step forward, three steps back approach with respect to delivery services in New York City and will create significant unintended consequences. Intro 30 would require delivery workers to have certified e-bikes provided by platforms, regardless of how much they use the platform. These amendments still completely ignore that restaurant delivery platforms are the only entities contributing to e-bike safety by paying workers an additional $2.26 per hour under the city's minimum pay rules, amounting to approximately $50 million to workers for the purchase of e-bikes. We remain steadfast in our opposition to any policy imposing overlapping expenses on a select few while ignoring businesses selling these dangerous products in the first place. Even platforms and the LDU can understand that imposing millions in additional costs on platforms could reduce or eliminate e-bikes as an option, essentially putting many out of work. Intro 737 and 738 mandate that platforms solicit tips at checkout and suggest a tip of 10%. However, the narrative is misleading. In reality, tipping post-checkout is to balance rising consumer costs resulting from the minimum pay rules. DCWP's support is surprising given the suggested changes to tipping on page 36 of their study. Still, higher consumer costs have resulted in an estimated 850,000 fewer orders for dashers and $17 million in lost revenue for merchants in just a 2-month period. Mandating tips at checkout will only exacerbate this. Worse yet, the proposals single out restaurant delivery platforms while others delivering groceries, alcohol, and other goods are not subject to any of the same pay or regulations. Finally, we oppose Intro 715, which would incentivize more traffic violations, not less. We look forward to continuing to work with the council over the summer on these concerns. Thank you.
Excuse me 1 second. We just want to take a moment to recognize we have students in the balcony from Ballet Tech Public School for Dance. We really appreciate you being here. Number of questions that I have for this panel, and I'm sure my colleagues do as well. So what have you done to ensure that your delivery workers are riding certified e-bikes and registered mopeds while delivering for your service?
Hi, Haley from Uber. I can answer this question in a few different ways. For anyone who says they plan to ride a moped to make deliveries on the app, we require them to upload insurance documentation as well as information from a registration. We also use real-time ID checks and reports from customers to make sure customers are on the right vehicle. For example, if they say they're on a manual bicycle and they're going 30 miles per hour, that's a clear indication that they're not registered the correct vehicle. Uber has also invested in partnerships in New York City, which go to increase delivery workers' access to UL certified bikes, including through the Zumo partnership, as well as the Equitable Commute partnership.
And what type of active training do you do for delivery workers?
We don't provide active training. We do send safety tips and road safety tips to delivery workers on a regular cadence.
What percentage of your delivery workers are using e-bikes and what percentage are using mopeds?
More than 50% of workers who registered through the app say they're using an e-bike or a manual bike. The use of mopeds is much, much smaller.
And what measures are you taking to ensure that individuals that are delivering on the platform have the proper equipment and are able to operate in a safe manner?
I'm happy to jump in, but also
I'll answer if you want.
Yeah, if it would be helpful.
Josh Bosian with Grubhub. Just to start off to say that I think most of our answers are the same to the ones that Haley already gave you. It looks like Cassandra agrees that most of our answers are the same there. So in terms of ensuring that individuals have proper equipment, so we cannot compel our contractors to use certain types of equipment. Safe delivery is required in our delivery partner terms and conditions. However, much like my colleagues here, we do send out regular communications to the couriers, making sure and encouraging them to follow the rules of the road, do things such as safe charging with e-bikes, making sure that they're doing what they're supposed to be doing. I would also say that we support bipartisan legislation that's currently pending in the United States Congress regarding UL certified e-bikes and e-batteries, and we actually think that those that are not UL certified should be banned. There was also a package of legislation that recently passed in Albany, which had, I think, 5 or 6 bills, if I remember correctly, that specifically dealt with e-bikes about, point of sale and that only UL certified batteries should be sold, et cetera. We supported that package of legislation as well.
And just to add to that, in addition to directly providing workers with financial resources to pay for e-bikes and batteries through the minimum pay standard, DoorDash has taken additional steps to support access to safe e-bikes. We improved the access to certified bikes by investing $250,000 in the Equitable Commute Project to fund the development of the first ever trade-in program dedicated to delivery workers in New York City. This program will run trade-in events on a bi-weekly basis to help delivery workers transition from their existing device to a new UL-certified e-bike. Delivery workers have 3 options to choose from, and e-bikes are priced as low as $700. Additionally, forging partnerships with reputable manufacturers and retailers to offer certified e-bikes to Dashers at affordable prices. We have partnerships with e-bike suppliers that offer delivery workers discounted bikes and batteries that are certified to UL standards. These collaborations allow Dashers to purchase e-bikes for as low as $949. We also invest in education, $100,000 in the FDNY Foundation to support battery safety education initiatives, and regularly update and remind Dashers of the best practices. We also advocate for Congress and the U.S. Consumer Product Safety Commission to set federal battery safety standards for e-bikes and all micromobility devices to stop uncertified products from entering the United States in the first place.
What changes have you made to the platform since minimum pay went into effect?
So at Grubhub, Councilmember, as the minimum pay went into effect, we've had to make adjustments to our platform to ensure that the number of couriers that are on the platform are in the correct correlation to the number of orders that are there. And so we've had to do things such as have couriers sign up for blocks, for example, in order to make sure that, again, we have the right number of people on the road in order to do those deliveries. This is an interesting conundrum because, in fact, when the DCWP passed the minimum wage, they predicted in their own study, and I would invite members of the committee to take a look at the study, that in fact the industry would be forced to become more efficient, which would likely result in less couriers on the road. That has come to fruition. We still have about 20,000 folks at Grubhub who are active on our platform at any given time, but I do know that's less than before DCWP's minimum wage. I will say that we think that there's a way to increase the number of couriers and to increase their pay, which is to pass Intro 762. We firmly believe that amending the cap on restaurants will lead to more exposure to diners, which will lead to more orders for restaurants, which will lead to more opportunities for the couriers to make deliveries, thus leading to more money. Okay,
I have a question on that, but before I move on to a question on that, any other comments that either of you want to make on that topic?
Was just going to say similar. Prior
Okay.
to the earning standard, we were open access. Since the launch, we had to limit workers' ability to go online in order to match the supply and demand.
So in jurisdictions that have enacted a cap fee, how many users opt for the minimum fee level and how many opt for the maximum fee level?
So I can answer this. So in similar jurisdictions where the fee cap has been amended, the overwhelming, and we're talking 90+% of our restaurants stayed at the exact same package that they had prior to COVID, prior to those fee caps going into effect. I can give you a specific example in San Francisco where we know that approximately 15% of our restaurants are at the basic package and about 85% of our restaurants or so in San Francisco opt for more services above the basic package.
I was just going to comment that the vast majority of caps since COVID have been repealed or removed by those jurisdictions, but we do offer merchants different pricing plans currently all over the country outside of New York City that range from light to premium options, and we see restaurants take advantage of that flexibility to choose the plan that works best for them.
I'm going to now turn to my colleagues for questions. Councilmember Breyer?
Yeah, I have a question for Grubhub. Can you please tell me whether or not your tipping option remained at checkout after after minimum wage went into effect?
Yes.
So what do you say about this notion from Uber and DoorDash that passing the minimum wage require them to remove the tipping at checkout? What do you have to say to that?
We're running our business and they're running their business. I'm not going to comment on how they're running their business. I think you're going to have to ask my two colleagues about that.
Well,
But council member, I will say this. That is correct. We did not change our tipping policy. However, we are under a tremendous pressure to do so from our business because we are now at a competitive disadvantage. What we have seen, and this you can take it from the company that hasn't changed this tipping policy, is that in fact, because of the DCWP minimum wage, we are actually seeing a decrease of approximately 25% of what our customers are tipping the couriers. So to say that there's not been an effect, we actually have data to show that there is an effect.
And just, the admin made clear that apps like Grubhub, which have kept tipping at checkout, for the most part even though there has been a slight decrease in tipping, it has been by far the most helpful for deliveristas. Compared to the other apps like Uber and DoorDash, we have seen an $85 million drop. So I guess I would ask DoorDash the question, what do you make of the fact that your colleagues at Grubhub have kept tipping at checkout, which have been favorable for deliveristas, and you guys decided against doing that?
Thank you. So similarly, I'm not going to speak on behalf of Grubhub, but I will speak on behalf of DoorDash and our position on moving tips to post-checkout. So because of the NYC Pay regulations, they force DoorDash and other platforms to increase consumer fees, as you know. In response to this, we made tips an option post-checkout. Not to make the intent wasn't to make tipping harder, but it was to limit the number of consumers who were abandoning placing an order because of the higher cost. Each lost order not only guarantees that there won't be a tip, but it results in no earning opportunity at all for Dashers. That's bad for Dashers, restaurants, and customers in the city. So making these tips available after checkout is not so nefarious and definitely not retaliatory. As I mentioned in my testimony, it was even suggested by DCWP in their own study on page 36 that I referenced, and you will all have a copy of that. It was suggested in that study of the pay standard as a strategy to reduce consumer costs. So this was acknowledged by the administration as well.
Understood, and what you're engaging in is not necessarily illegal behavior, but it is certainly behavior that has bad intent and is behavior that it is, I believe, inconsistent with the needs of deliveristas. You mentioned in your testimony that orders have decreased. The admin said 8% has increased. How do you reconcile the admin's testimony versus yours? Is there false reporting or is there actual decrease?
I have the same question. That was the first that I'd heard of it, and we are looking to follow up with them to find out.
Because there is a reporting requirement, and they said it was 8%. And in your testimony, you mentioned that it's for a period of 2 months.
That's right.
So I'm curious to know if that overall year period, if that matches what's been reported, because that discrepancy is very concerning.
And it's significant as well that the last 2 months, those numbers, as I mentioned, are 850,000 drop in orders and $17 million in loss of revenue. So that's just April and May alone. So we can certainly...
So would you say that the administration is lying?
No, I would not say that. I would say that we have to talk after the hearing and figure out all of the numbers and compare.
So they're either lying, they're misreporting, or what you said does not characterize the entire year period that they reported.
I'm not speaking for the entire industry, only for DoorDash.
Yeah, okay.
Councilmember Salamanca, questions?
Yeah, thank you, Madam Chair. I want to thank the panel for being here today. Just want to speak a little bit about Intro 762. I know that there is some opposition on it, and I just want to get some clarity. I thank you for the Cranes article, New York, that came out. So it mentions, I know that the person who wrote this op-ed is Lisa Servin. She is from the Bronx Chamber of Commerce. And she makes mention in terms of the Bronx Chamber of Commerce being in favor of Intro 762. But something that was quoted here, and I just wanted to get your intake on it, in terms of the opposition for the bill. It reads that opponents of this bill have argued that this amendment would just allow delivery companies to charge restaurants more for marketing services. Can you speak a little bit about that?
Sure, Councilmember. I'll take a first stab at this, and then I'm sure my colleagues will either correct me or jump in. So I think that there's a great misconception out there that, in fact, Intro 762 lifts the cap completely, and that the cap completely just goes away. Let's keep in mind here, and let's remember that at the height of COVID, there were about 92 such caps that were in place across the entire country, in municipalities small and big. There's one left of this type, and it's here in New York City. So we are not lifting the cap completely. What we're doing is we are amending the cap in a similar way that the cap has been amended in major municipalities all across the country, whether that be Chicago or Philadelphia, Seattle, San Francisco, just to name a few. 762 is literally the culmination of 2+ years of conversations with the council, with restaurants, with advocacy organizations to try and find a way to continue to give restaurants guidelines and guardrails, rather, and at the same time allow us to continue to operate here in New York City. So let me go through some of the safeguards that 762 specifically has for restaurants. 1, the right to be listed and discoverable on the platforms. 2, the right to include their own marketing materials in the deliveries. 3, to set their own in-app menu prices. 4, the right to prohibit delivery platforms purchasing their restaurants' names for advertising. And finally, it requires DCWP to do compliance assessments on a regular basis. We have literally put everything in this bill and agreed to everything that we've been asked to by the council. And council member, I would invite you, when other folks come up here today to perhaps testify against this piece of legislation, to ask them what more that they want, to ask them what else we should put in the bill, to ask them what their suggestions are, because we have been asking for 2.5 years, and we have yet to get an answer.
Thank you.
Thank you, Councilman. I want to have an opportunity to respond to that as well, and to add to it that because of the way that the amendments in this bill are structured, the platforms will be required to provide the restaurants the option to obtain delivery for a 15% commission, as you're well aware, and non-delivery services, such as pickup and listing fees for a 5% commission, plus transaction fees inclusive of marketing or any other fees. If restaurants want to pay more for additional marketing, they're free to do so, but they are not required to do so. In addition to the increased customer visibility restaurants receive on Plus and Premier plans, DoorDash offers restaurants access to sponsored ads and promotions, a $0 delivery fee for customers on DoorDash Marketplace. DoorDash also invests in marketing and advertising for DoorDash Marketplace, which helps drive growth for restaurants.
So what would happen if a restaurant were to choose the minimum package in terms of marketing?
So all restaurants, regardless of what package they have, will be searchable and will be able to be found on the platforms. That is a guarantee of Intro 762. Nobody gets hidden. Does not matter what package you have.
All right, thank you. The council members that the chair stepped out for a minute, she asked me just to take over, so we're just gonna hand it over to Council Member Oswald for at least for questions.
Thank you so much. Thank you. So a few questions for all of you. What's your position on Intro 30A, which requires that you verify UL certification and provide a UL certified e-bike, and also Intro 972, which requires you verify licensing for if mopeds are used for deliveries?
I can start. I think on Intro 30A, thank you. I know we've been talking about this for a long time. I appreciate the new language. It was nice to see that it was broader and more inclusive so that third-party grocery delivery services, other restaurants, or other small businesses that contract with workers who operate on e-bikes would be included in this. However, I still have concerns that so far this is the only industry that's currently paying workers a wage that has allocation for expenses that should be going towards e-bikes as stated in the study. I think from only Uber's data, we know that, sorry, I have a number here. More than 9,000 workers have already earned at least $900 towards expenses since the earning standard went into effect. The DCWP in their study said that a new e-bike is $1,800. So it's reasonable to expect that after 1 year, they'll have earned enough to purchase a UL certified e-bike based on the DCWP's study. So that is a concern of ours that remains.
Okay, what about Intro 972, which requires that all of you verify the licensing for mopeds?
Sure, happy to start. I think, we're open for discussion on that. We do currently collect insurance information as well as information that comes from the registration of a vehicle for delivery workers. That bill, I believe, it's similar to 30A, be expanded to include other companies that operate with mopeds. But I would love to talk through some flexibility of how we collect that information and what exactly verifying registration means. We are not the DMV. Of course, we would want to, have a better understanding of what exactly that means to the council.
Okay, and can we also hear from the other companies? Same two questions, 30A and also 972.
Yeah. Thank you, Councilman. So on the mopeds issue, it has been difficult to invest more on the e-bikes, the battery safety initiatives, when we're already directly compensating the workers for the e-bikes and the safety equipment. We feel that the platforms in the city must come together to align on how we can contribute to this issue and not have duplicative and unsustainable requirements. We, like the city, have also struggled to identify the best way to actually help this transition occur and think the city's participation in a trade-in scheme is essential to that success. Additionally, on the mopeds, before gaining access to the Pro platform, every prospective dasher must have a current valid government ID. This is for e-bikes and also mopeds alike. They have to have a social security number and complete a background check. Dashers using motor vehicles, including mopeds, have to have a driving history check is also run, verifying their eligibility to drive. It also provides an individual's driving record, driving history, and minor violations such as speeding or running stop signs. Even after this approval to dash, dashers undergo regular background check reruns to ensure our records are up to date, dependent on DMV record databases, and to evaluate any new information that should be considered in determining dashers' eligibility to continue on the platform.
So, Councilmember, let me take the second question first, which is the moped registration question. I think currently, as the bill is written, we oppose the piece of legislation simply for the same exact reasons that my colleague Haley at Uber said, which is I'm not sure how we verify or certify a registration, right? We're not the DMV, we're not the DOT, we're not the NYPD, and we don't think that we should substitute for a city or state agencies whose job it is to do that type of enforcement. However, we do require currently anyone who is deciding to operate via moped or car to upload their registration, much like Uber Eats, when they sign on to our platform to become a courier. So that would be that question. I think we could potentially continue the conversation with Councilmember Powers to talk through that. In terms of your legislation, Intro 30A, if by my count, I think this is the third time that we've had a conversation or a hearing on 30A, right? I think it was last October, January, now we're back. Much like my colleagues, I think we're very appreciative of the fact that you've expanded the folks who are covered under this bill, and I think that that's a good first start. However, I think we're still in opposition to it because we're running into the same problems. If if you work for all, or if you deliver for all three of our companies, how many e-bikes do you get? How many e-batteries do you get? Do you get 3? And in addition to what Cassandra said, there's already $2.26, which is specifically built in to the DCWP minimum wage, which is supposed to go for this exact type of thing, for this exact thing of safety equipment. So for us, it feels like we're getting hit twice, where we're paying $22.26 in the minimum wage for safety equipment, and then we would be asked to do it again. So I think to your point, we're not sure the bill is quite ready yet, and perhaps we need to have some additional conversation. I just do want to add one other thing. I thought Councilmember Menon asked an excellent question of the administration when she said, what's the status of the idea of the Office of Sustainable Micro Delivery or whatever? Sustainable Delivery, thank you. I always get it wrong. We all sat through a meeting with the administration regarding that proposal. I think we thought it was somewhat of a good idea, right? Let's put everything that's kind of in these disparate city agencies right now into one office. Let's see if we can solve the problem holistically and do it that way. And we'd love to see what the status of that office is.
All right, thank you. So 2 points. And I guess the first point is on the issue of moped registration verification. I know some of you mentioned that there are some systems uploading insurance information, et cetera, but I think anybody that, again, just spent 1 minute looking around in the streets of New York City would agree that whatever system we have in place has the same exact effect of having no system at all. Whatever all of you have in place on that issue is not working, not even close to working. And on the minimum wage issue covering UL certified e-bikes, what about new workers? What about workers that are starting afresh, they want to do delivery work, but they'll have to work a year with an uncertified e-bike before they could actually afford a certified one, based on the wage-related numbers and the pricing for these e-bikes. So that's 1 year that they need to work, putting their lives at risk, putting their homes at risk through a fire, and et cetera. And I think that that's a major problem. And it seems like on all these issues, it seems like the overall narrative or the thing that I hear from all the companies is, let the issue potentially go away on its own. We don't want to play a role. And I think that's very problematic. So a few questions on that. So what exactly are you doing to resolve the fire safety crisis that we're in? And yes, it's a crisis. Again, 97 fires last year from January through end of May. This year, similar numbers. We're in a crisis. So what exactly are you doing to resolve that? I know you mentioned the equitable commute project. What else? And what do you say based on the numbers? Are you doing enough?
Well, I want to respond to what you just said about how a new worker would have to use a uncertified, unsafe bike for a year before being able to afford a UL certified bike. I think that's exactly why we've set up these partnerships in New York City. Like Uber has Zumo, I think Grubhub is with Joco, so that workers can rent on a weekly or a monthly basis as they start out on the platforms and earn money in order to save up for a UL certified bike. So there's nothing that we're not hoping that workers buy an uncertified bike as they start working on our platform just to earn for a UL certified bike.
And I can add to that as well. This would require a lot of, partnerships with the industry and with the city as well, specifically on proof of UL compliance for e-bikes. Right now, this is a pointless exercise because it would require us to remove almost every e-bike-based worker that uses our platform because very few workers have UL certified devices, as was mentioned. We believe the city did the right thing by setting safety standards, switching from no standard to UL 2849, and it was a fairly quick change to a standard that relatively few bikes are certified to. Even major reputable manufacturers have only recently been able to catch up. Other efforts to reduce fires by manufacturing UL certified replacement batteries for older products are only just becoming available. Asking platforms to do this right now is essentially asking us to cut off tens of thousands of people from work.
And based on the different programs that you've worked on, we've had a lot of conversations about them, the rentals, e-bike rentals, the equitable commute project. More or less, how many delivery workers could they potentially cover? Based on their fleet, amount of e-bike rentals available, and et cetera.
I don't have specific numbers. I know that the Zumo partnership, they recently got a new delivery of UL certified bikes in just this last quarter, so I would have to check on the number. But I think each of these programs began last year and they had a slow ramp up, but what we've seen is more and more uptake as people become more familiar since the city's new standards went into effect. So I can follow up with you on specific numbers related to those two programs.
All right, what about the others?
Yeah,
Left or
no,
right?
Councilmember, Grubhub has two partnerships, one with JOCO and one with an organization like Wiz. I don't have the exact number sitting in front of me, but if you get in touch with us afterwards, I'll be happy to get you the data that you're requesting, not a problem.
Okay. All right, well, thank you so much. And again, just want to reiterate, we have issues, and whatever has been done is not even close to being enough. We're in the same position we were at last year. So whatever has been done is not even close to being enough. We have issues, and the companies need to play a role in resolving them. Workers make these companies. They make these companies possible, and companies should look out for the workers a little bit more, and look out for their safety, for their homes, and everything else. So yeah, thank you so much.
Thank you, and thank you to this panel. We are now going to move on to the next panel, which will be comprised of Andrew Ridgey and Chris Lauber. Please come up. Thank you.
Good afternoon. My name is Andrew Ridgey. Oh, ready to go?
Yes, please.
Oh, thank you. My name is Andrew Ridgey, and I am the Executive Director of the New York City Hospitality Alliance. We represent restaurants across the 5 boroughs. We strongly oppose Intro 762. The third-party delivery companies have given this bill the phony name, the Fair Competition for Restaurants Act, which is the exact opposite of this proposal. Let's call it what it is, the bigger fees for big delivery bill. Today, the City Council is hosting another hearing on another package of bills to further regulate third-party delivery companies because they're continually bad actors. Still, they've been able to obscure the intent of 762, which deregulates them to where they're having it considered. The City Council should not further entertain changing this fee cap law while DoorDash, Grubhub, and Uber are suing the City of New York to overturn this very same fee cap law. So far, their lawsuit has been unsuccessful. They are also suing the city to overturn another law this legislative body passed that would prevent them from withholding a restaurant's own customer information from the restaurant, which is the technique they use to control the consumer marketplace. It's monopolistic-like behavior. Intro 762 will increase the maximum fees, the current cap of 23%, to letting third-party delivery companies take a whopping 43% of each order from a restaurant, while also charging the consumer a fee too. The average restaurant has single-digit profit margins, if they're making any money. Does the City Council want to let third-party delivery companies take nearly half the money of each restaurant order? Yes, the companies have agreed to a few good amendments that the Hospitality Alliance advocated for as standalone laws that should be enacted, but not as part of a negotiation to gut this fee cap. Now, I have a little, can I go? I didn't bring tons of people here, so if I could get.
Yeah, we have to have everyone speak the same round, so if you could please wrap up, and then you can submit your written testimony.
Will do. The most important thing is that the companies are saying that the 5% marketing option will make them require restaurants are listed and discoverable. But this bill does not define what listed and discoverable is. Under this language, they could technically make a restaurant listable and discoverable, but only if a restaurant customer types in the exact name, or if a customer is ordering from maybe a 2-block radius. There's various ways they can obscure this and make it
I have to ask you to wrap up, please. Thank you.
So we're happy to obviously submit all of our testimony, but these companies have showed you over and over again who they are. The council and restaurants should believe them.
Okay, next speaker, please.
Thank you, and good morning to, I should say, actually it is still morning, technically, to members of New York City Council and attendees. My name is Chris Lauber. I'm the manager. I've managed restaurants and hotel operations in New York for over a decade, advised in some of the top hospitality technologies used today, and I'm currently the Senior Director of Operations for a restaurant group here in New York City. I'm here today to urge you to maintain the fee cap for the delivery platforms, as they're essential for the survival of restaurants in our city. The fee caps implemented during the pandemic have been a lifeline for countless restaurants. The pandemic hit restaurants and hotels very hard, and the delivery platform usage actually soared. Restrictions for the indoor dining further increased the reliance on these delivery and takeout platforms, altering the landscape of our industry. The fee caps have changed and created different layers of marketing caps and fee caps and credit card caps and otherwise, but these caps have been in place to check the absorbent fees from the platforms that would otherwise charge whatever they would like. Without these caps, restaurant fees could double or worse. From an industry with thin profit margins of 5 to 10%, increasing these fees could mean the difference between staying open and closing. Recently, I even had to argue with multiple platforms just to abide by the current regulations in place and not overcharge us when onboarding our restaurants. So, removing the fee cap would disproportionately affect smaller independent restaurants and bring bargaining power to larger restaurants, further creating an uneven playing field that favors larger chains. Small businesses in New York City create the vibrant culinary scene and culture that we have. And so in conclusion, I would say maintaining the marketing fee caps is crucial for the survival of independent restaurants in New York. I urge this council to consider the long-term implications of lifting these caps. I would also like to add that with these caps, searchable and discoverable is my #1 concern, because we find that they are looking to find exponential ways to add on to their potential fees.
Okay, thank you for your testimony. I have a couple questions, and I'll turn it over to my colleagues for questions. So with Intro 762, since it's voluntary as to whether or not a restaurant opts to do it, it's an opt-in, why still the concern?
Well, I would just say that, this didn't start at the beginning of the pandemic. The reason we got here was because multiple hearings in this council about how they use their market leverage and control to essentially force restaurants to increase the fees that they pay. If you don't pay to play, you essentially disappear. And that's why I mentioned listed and discoverable. It essentially means nothing without it being defined. Sure, if I pay 5%, I can be technically searchable, but not accessible. And then the representative goes to the pizzeria across the corner and around the corner and says, if you don't pay, if you pay 25%, you can basically take the business from the other restaurant. So they continue to play each other off of each other. And it's important to note that the lawsuit, another one of their lawsuits, difficult to keep up with all the times these companies sue the city, but the council did pass a law that it required the companies share customer information with the restaurants, and because they withhold that information, restaurants can't even directly market via email and so forth. So they have a very sophisticated way of essentially leveraging their market share and power to force places to pay up. And if they don't, they lose their business. It happened year after year after year, and it's why we ended up here in the first place.
And can you comment on other cities that have similar legislation and the impact there?
The ones that gutted the fee cap?
In other words, other cities that were mentioned earlier by some of the third-party apps, San Francisco and other cities, and how this kind of program works there.
Yeah, their aggressive lobbying campaigns were successful at gutting the fee cap, and they have issues like the ones that we've laid out. I mean, New York City always talks about wanting to be the leader. We were a leader with this fee cap, and the fact that we still have it in place should be something that a city that leads wants to promote, not be shamed about. So, And again, I can't speak specifics of the whole history there, but we have a long documented history of the exploitation of local restaurants by third-party delivery companies, much of which has been documented in these chambers.
So are there services that you want to receive from third-party food delivery services that aren't currently available?
Would you be able to better define the question?
Well, in other words, are there things that you think the third-party delivery apps should be offering to restaurants that they're not offering? Are there things that would be value added?
At the current 5% rate, it appears to be an even playing field within New York City. It's more based around proximity or specific cuisine you're searching inside of an app that then allows you to be found. The concern underneath this 762 is that searchable and discoverable does not define how hard you have to search to discover the restaurant you're looking for. Therefore, it would create an uneven playing field. For example, if, as Andrew mentioned earlier, our restaurants had been next to each other, right, and they had two different marketing strategies inside, we would then have one exponentially higher than the other, which is ultimately what they're arguing is the point. However, the margins are so thin going into restaurants to begin with that it creates kind of an effective rat race that would be exponentially playing one off of the other to get higher and higher in the fee cap until eventually it's exhausted.
They could drop their lawsuit on the customer information. One of the things that restaurants want is to be able to market directly, digitally, to their customers. That's why, but the third-party delivery companies withhold that information from the restaurants. That's why this city council passed a law that has a stay because they're suing over it not to provide that information. There's another thing. For example, if you're paying for marketing and get me a new customer, incremental business, yes, that in theory is worth more. I'll pay a little bit of a higher marketing fee if you're bringing me a new customer, a new order I would not have normally had. I'll pay 15% for that order. But what happens when that customer orders again? Why am I continuing to pay 15% or 20% when it's not a new sale? So I think there are plenty of ways that these companies could work better in a more fair way with restaurants. I dispute the claim that they've done everything and they haven't been everything that has been asked for them. There is tons and tons of things that have been asked for them that they haven't done. This is the classic sleight of hand. Look over there, but don't look over here.
Okay. And do any of the colleagues have questions? Councilmember Salamanca.
Yeah, I just have a few questions. Thank you for your testimony. I have just a question. So I know that in the previous bill, I believe it was 813, there was opposition, great opposition from other restaurant associations. But I've seen with this new revised bill, that opposition has leaned to being in favor of that bill. One of them being the New York State Latino Restaurant and Bar Association. Can you explain to me why now those individuals that were not in favor of the previous bill are not in favor of the bill today?
I'm going to be careful. These folks are my good friends. I've been doing this for 20 years. My integrity runs on this. Different organizations are going to make different decisions for different reasons, just as elected officials are going to do, hopefully, what you all feel is right. I've studied these issues. We're all going to have to answer to our members eventually. And while they may feel they are doing the right thing, that is in their right. I believe it is very misguided to agree to this bill as is. And we will continue to fight and represent our members, represent what we believe is right, because we don't want to have to be back here with our friends again, who may be on the opposite side of it now, saying, oh, maybe we got to go back and do something. And I would just say, this day is a perfect example. You passed the minimum pay rate. They lobbied hard against it. You still passed it. What did they do? They sued. Guess what? As you know, the court upheld the minimum pay rate. So what did they do? They went and obscured ways and made it more difficult for the folks to tip. And now you have a bill today to address that. I would suspect that if you were to pass 762, we would be back here in the future and dealing with the same types of issues that we have been dealing with for years and years. Sorry, I was a little long-winded. But.
No, I appreciate your comments. I just, on the original bill, I was on it, and I was just getting bombarded with calls from my friends in the hospitality industry. And those are the same individuals, once this new bill was introduced, giving me a call saying they are in favor of this bill, let's make it happen.
And I know others who are not, and I will tell you I've been receiving emails from restaurants that are receiving stuff from many of these companies, robocalls. You know, you are all professionals at this. You know that when you lobby hard enough and throw enough money at stuff and do as much public relations, you can get people to come out and testify against what I think is their own interest. But like I said, people are going to do what they feel is right. Just with my 20 years of focus on all of these issues, I just have a very, very bad feeling, especially as this bill is drafted, because while it does other things, it's not putting any guardrails on the most important point, which is the listed and discoverable piece and the percentage.
All right, just one last question. I just want to get your comment on this op-ed that was written.
From Lisa?
Yes. It says opponents on this bill have argued that this amendment would just allow delivery companies to charge restaurants more for marketing. But that claim fundamentally misses the point of this bill. What is your comment towards that statement?
Well, that's what it...
Opponents of this bill argue that this amendment would allow delivery companies to charge restaurants more for marketing. But the claim fundamentally misses the point of this bill. The amendment strikes the right balance of small businesses because it empowers restaurant owners to make decisions that are best for their own businesses by ensuring that platforms maintain low-cost options that still provide exceptional services to local restaurants and unparalleled access to thousands of customers across New York City.
I love Lisa dearly, but I think it completely misses the whole entire point. And it's exactly what these companies want to say. It's an illusion of power. The real reason that we got here before the pandemic, you know, why this was an issue, it was the illusion. It's like, yeah, you know, you can pay nothing and you basically get nothing. But they have a very sophisticated way of basically leveraging these businesses to get them to pay more. So sure, you know, they can in a sense pay more for marketing, but what happens if they stay at the 5% level, right? If I'm a restaurant in your district and I say, you know what, I'm just going to continue to pay the 5%. Are these companies going to guarantee that they're going to stay at the same delivery level? Or is Grubhub or DoorDash or Uber Eats going to go to that same restaurant in your district and say, hey, you know what, the competing restaurant across the street is now paying 25%. Mr. Restaurant, Mrs. Restaurant, you know, if you start paying me more, then you could start competing. And they play each other off each other. I mean, this is just what happens. So I would just say in response to that is that it's an illusion.
All right. I appreciate your statement. Thank you, Madam Chair.
Thank you.
Thank you. Any other questions from colleagues? If not, we will move on. Okay. Thank you very much to this panel. We appreciate it.
Thank you.
Okay, I'm going to call our next panel. Luigia Gualipa, Alejandro Grajales, William Medina, Antonio Salas. Please come up. Thank you. Okay, thank you. I'm also going to note we've been joined by Councilmember Brewer.
Ready? Yeah, okay.
Please go ahead. Thank you.
Thank you. So thank you so much, Chair Menon, for the opportunity to testify today. Also, sponsors Sean Abreu, Oswald Solis, and Lynn Schulman for giving us the opportunity. So my name is Ligia Hualpa. I'm the Executive Director of the Workers' Justice Project. I want to thank Commissioner Bilda Mayuga and the Department of Consumer Worker Protection for their partnership, actually not only implementing minimum pay, but also holding apps accountable. We've been able to collect unpaid wages from DoorDash and educate hundreds of workers. Over the past 6 months, we have witnessed the transformative power of minimum pay, lifting delivery workers out of poverty. But the fight is far from over. The apps continue to retaliate and sow division. Since the implementation of minimum pay, DoorDash, Uber have removed the tip option before delivery, a system that they had in place before and were used and are actually intentionally used to discourage tipping from consumers. This tactic is hurting workers and is misleading the public and and it's directly impacting workers' pockets. We're thankful for Intro 737, Intro 738, which will focus on tip transparency. These bills require app delivery companies to actually show tipping at the beginning of checkout, essentially restating the system that they had in place before. Intro 859 will require will actually give an ability for workers to be able to see their pay and actually plan their finances in advance, which is something that we should all have the right to do it. While we deeply appreciate the advocacy and the partnership of Councilmember Oswald Feliz, Lynn Schulman, and Keith Powers, and their noble intentions of legislation Intro 30, Intro 715, and also Intro 972, we strongly support these intentions. Our concern is that without the activation protections could lead from thousands of people losing their jobs. So we want to be able to work with City Council and council members to be able to ensure that workers have the activation protections and incorporate legislative language that secure more protections, giving power to workers to fight back unfair deactivation.
Thank
so
you.
we
I'm
look
just going to
forward.
ask you to wrap.
Yeah,
Thank
so
you.
we look forward to building a stronger language so we can have more comprehensive legislation that would lead to holding these apps accountable. So thank you so much.
Thank you.
So I'm going to be translating after he speaks.
Okay, thank you.
Buenos días, gracias a la presidenta del Comité de Consumidores y Trabajadores, Julie Menin, y a todos los miembros de este comité. Mi nombre es Alejandro Grajales, soy deliverista y miembro del Proyecto de Justicia Laboral y los Deliveristas Unidos. Llevo aproximadamente 9 años trabajando como deliverista con las aplicaciones como Grubhub, DoorDash y Relay. Durante los últimos 6 meses hemos sido testigos de las represalias tales como haber removido la opción de la propina al principio del proceso del pedido, restricciones de horarios, falta de transparencias en el pago y bloqueos y desactivaciones injustas. La realidad es que estas aplicaciones cada día son más abusivas y nos presionan para aceptar todas las entregas. Nos empujan a cumplir las entregas en un tiempo muy corto sin tener en consideración si hay tráfico y si hay condiciones climáticas adversas. Las aplicaciones usan las calificaciones para penalizar si no entregamos a tiempo, si no aceptamos todas las órdenes o por errores del restaurante o el cliente. Desde la implementación del pago mínimo, DoorDash y Uber eliminaron la opción de dar propina antes de la entrega, un sistema que tenían implementado y al que los consumidores estaban acostumbrados durante años para desalentar las propinas. Las aplicaciones siguen sembrando división y confusión. Un ejemplo de esto es el correo electrónico que recientemente envió DoorDash amenazándonos que van a remover la propina y sembrando más miedo, confusión y división entre los repartidores. Al quitar la opción de dejar propinas al principio del pedido, estas aplicaciones no solo están subestimando nuestros ingresos, sino también desvalorizando nuestro trabajo y contribución a nuestra comunidad. Muchos de nosotros seguimos enfrentando bloqueos arbitrarios o desactivaciones injustas. Esto nos deja vulnerables y sin protección, con consecuencias devastadoras para nuestro sustento y bienestar. En conclusión, aunque hemos logrado un gran avance con el establecimiento de un salario mínimo, necesitamos su apoyo para luchar contra las represalias. Exigimos que se restaure la opción de las propinas al principio del proceso de pedido, se aumente la protección contra las desactivaciones injustas y se garantice una mayor transparencia en el pago. Por eso estoy aquí para apoyar la propuesta de ley 737 y 738. Juntos podemos continuar luchando por un futuro más justo y equitativo para todos los deliveristas. Muchas gracias por escucharme.
Yeah, I'm going to try to summarize as quickly as possible. So my name is Alejandro Grajales. I'm a deliverista. Over the past 6 months, we have witnessed the retaliations such as removing the tipping option from the beginning of the order, setting unfair scheduling restrictions and unfair deactivations. The reality is that these apps are becoming more abusive every day, and they're constantly pressuring us to accept all deliveries. They're pushing us to fulfill orders in a very short time without taking in consideration the weather, the traffic, and other working conditions. Apps are using the algorithms to penalize if we don't deliver on time and if we don't accept all orders from the restaurants. Since the implementation of minimum pay, DoorDash and Uber have eliminated the option to tip at the beginning of the order, a system that they had in place before and that consumers were used to already. The apps continue to sow division, confusion. An example of this is that DoorDash recently sent an email threatening us that they will completely eliminate the tipping option, creating more fear, confusion, and division. By removing the tipping option at the beginning of the order, these apps are not only undermining our income, but they're also devaluating our work. Many of us continue to face arbitrary lockouts, unfair deactivations. This leaves us vulnerable and unprotected with devastating consequences. We demand the tip option to be restored at the beginning of the ordering process, and we strongly support Intro 737, 738, and together we can fight together for a more just, equitable future for all deliveristas.
Thank you to the President of the Consumer and Workers Committee, Julie Menin, and all the members of this committee for the opportunity to speak today. My name is William Medina. I'm a member of the Worker Justice Project and leader of Los Deliveristas Unidos, and I'm currently delivering for Uber Eats. Delivery work in New York City has become an essential job that deserves labor protections and recognitions. In extreme heat days like today, we cannot afford to stay at home, but have to work in the streets to bring food to our families' table, put a roof over our family heads. As independent contractors, we don't get the same labor protections like most New York City workers. We don't have the right to a safe workplace. We don't have the right to be protected from unfair deactivations, which is a force fighting us. We don't have the right to refuse to work in a situation in which I will be exposed to hazards. In the past 6 months, DoorDash and Uber Eats removed the tipping option until after the order was delivered to discourage consumers from tipping. This tactic is intended to hurt our wallet and mislead the public. While they continue to make millions in profit, also other apps like Hungry Panda forces workers to pick up more than 4 to 7 orders at the same time just to save money and put pressure on deliveristas to drive fast and avoid being penalized by the apps. The apps are using the activation to pressure us to drive unsafely. Also, the app removed the tipping option of consumer with the clear intention to hurt us. Many deliveristas have seen a significant decrease in tips because consumers are no longer provided with that option. I strongly support in 737 in 738, which each intend to bring us to what used to be norm and common practices before. Please note that DoorDash has threatened to remove the tipping option if this bill is passed. We need a council to create stronger languages that will mandate apps to provide tipping option to consumers if Grubhub
Okay, I'm going to ask you to please wrap up.
Uber can do it as well. Sorry.
Then you can submit your written testimony. We just have to give every speaker the exact same amount of time.
Thank you.
Great. Thank you so much. So a couple questions. So sorry.
Thank you. Buen día. Gracias a la presidenta del Comité de Consumidores y Trabajadores, Julie Menin, y a todos los miembros de este comité. Mi nombre es Antonio Solís, soy deliverista, miembro activo del Proyecto de Justicia Laboral y líder de los Deliveristas Unidos. Llevo 5 años trabajando para DoorDash. Agradecemos al concejal Abreu por su liderazgo en el intro 737 y en el intro 738, que se centran en la transparencia. Estas propuestas de ley requieren que las aplicaciones de entrega presenten claramente una opción de propina al momento del pago, esencialmente restableciendo el sistema que las aplicaciones ya tenían anteriormente. He sido testigo de cómo DoorDash ha eliminado la opción de propina con la única intención de proteger sus intereses y afectar nuestros bolsillos. DoorDash esta semana nos envió un comunicado amenazándonos con eliminar la propina con un correo lleno de mentiras y con la única intención de crear división entre nosotros. En mi testimonio está la copia del correo de DoorDash que envió esta semana. La actitud de DoorDash es un insulto y una demostración que a estas aplicaciones no les importamos y nos continuarán tratando con mano de obra desechable, sin derechos y sin protecciones. A pesar de los ataques, la división y la desinformación, estamos aquí luchando para tener derechos y poder luchar contra las desactivaciones, restricciones de horarios y tener más transparencia con el pago y que regresen las propinas. Grubhub es la única compañía que no removió la propina al inicio. Esto nos deja en claro que DoorDash y Uber lo hicieron con la única intención de de afectar nuestros ingresos. También apoyamos la buena intención de otras propuestas de leyes que sin protecciones contra las desactivaciones, lo único que van a lograr es generar más desactivaciones. Necesitamos protecciones con las desactivaciones para evitar retaliaciones que nos hacen las compañías, ya que cada día los trabajadores sufren de diversas represalias. Gracias.
So we are grateful to council member and also the chair for the opportunity to speak today. I'm here in support of Intro 737 and 738, which focuses on tip transparency. I have witnessed how DoorDash have made it harder for consumers to tip with the sole intention to hurt our pockets and protect their interests. This week, DoorDash sent us a communication threatening us to eliminate the tipping if these bills are approved. The communication email is full of lies, clearly sent to all deliveristas with the sole intention of creating division, confusion. I'm including in my testimony a copy of that email for your reference. DoorDash attitude is an insult and is a demonstration that these apps don't care about us and will continue to threat and treat us as disposable labor without rights and without protections. Despite their attacks, the division they're creating, the misinformation campaign, we will continue to fight for more rights and protections. And we urgently need deactivation protections, tip transparency, pay transparency throughout this process. Grubhub is the only company that did not remove the tipping, which clearly is an example that Uber and DoorDash did this intentionally with the sole intention to reduce our earnings. We're grateful with the other bills, Intro 030, 0970, 715, which we support, but without deactivation protections, it would only hurt us and create more deactivations, causing many of us to lose their jobs. We look forward to working with you, especially to create together, to be able to fight together to make this job safer and better for all.
Thank you so much. I have a number of questions. So I just want to make sure I understood you correctly. The copy of the email that DoorDash sent is part of the testimony so that it will be provided to the committee. Thank you. That's very helpful. In terms of safety information that the companies are giving, what information are they giving to workers, and what do you feel is the best way for them to give safety information to workers?
En cuestión de
Bueno, información de cómo operar nos han mandado unos flyers de cómo usar las vías y todo, pero nos falta más todavía, nos falta infraestructura, nos falta que den equipos más de seguridad, no sé, nos faltan muchas cosas. Como somos contratistas independientes, nosotros tenemos que hacer gasto de todos, cascos, protecciones de un buen pantalón cuando hay lluvia, cuando hay nieve, todos esos gastos nosotros los tenemos que como contratistas independientes comprar de nuestros bolsillos.
So what I have seen is that they have sent us a flyer, but that's not enough. We need to make sure that there is infrastructure, but also we need to make sure that as independent contractors, it is important to know that we are responsible of all the operating costs, from the devices, from the safety gear, from the safe equipment that we have to acquire, and somebody has to be responsible for that. And that's why we need to make sure that more is done.
Thank you very much. I just want to see if any of my colleagues have questions. Nope. Okay. Thank you so much. Councilmember Feliz.
Yeah, no questions, but just want to thank all of you for all the work you do. You know, we in the City Council, we do very important work, and we could only do it right when we work with people like all of you, work with all of you, and also listen to all of you. So just want to thank you for all the work you do, doing a great job amplifying the voices and the needs of delivery workers, and great speaking with all of you as well about Intro 38. I look forward to working together to add those additional protections that all of you mentioned. Thank you so much.
Great, thank you. Councilmember Abreu.
And to deliveristas, you already know where I stand on the issue. You know that I'm with you at every step of the way. I feel very, very confident that we'll get these through. So thank you for everything that you're doing. Keep up the faith. Keep speaking for yourselves. And again, I hope that what we can do as a council is going to improve the lives of you and your families.
Thank you.
Thank you.
For the support.
Y si se puede.
Thank you very much. I'll now call up the next panel. Paul Zuber, Brianna January. Bear with me. Justin Nelson. Millie Seiler, and Jari, sorry, it's hard to read, is Saldana, I believe it is. Okay, please begin.
Good morning, Chair, esteemed committee. For the record, Brianna January with Chamber of Progress in strong support of Intro 762. Chamber of Progress is a tech industry coalition promoting technology's progressive future and inclusive access for all to that future. I'll note that while our corporate partners do include tech innovators like DoorDash, Grubhub, and Uber Eats, they do not have a vote or veto on our positions. That said, Chamber of Progress is in strong support of Intro 762, and we thank the good bill sponsor for putting this compromised approach forward. Importantly, committee, restaurant associations across the country have supported similar measures in other major cities and even helped inform the suggested cap update here. My industry colleagues explained the mechanics of the bill, and you do have a copy of our written testimony, so I won't be repetitive, but I do just want to emphasize that Chamber of Progress's support is really based on the city's small businesses and consumers alike. Committee, New York's independent restaurants, under 762, New York's independent restaurants will have access and flexibility that could be transformative. Small businesses are more likely to benefit from marketing and visibility on these delivery platforms, which in turn would then help level the playing field with widely known chain restaurants. And consequently, we believe that this would ultimately help lower prices for consumers that are living in and visiting New York City alike. For these reasons and for the benefit of New York's consumers and small businesses, Chamber of Progress encourages you to pass Intro 762's compromise approach, and I thank you for our time.
Thank you. Next speaker, please.
Good afternoon, Chair Menon and members of the committee. On behalf of the Bronx Chamber of Commerce, please accept this testimony in support of Intro 762 legislation that would amend the city's price control on third-party food delivery. We support the bill because it will promote the success of local restaurants in New York City, and it will help ensure they have access to the products and services they need to reach new customers and grow their businesses. The Bronx Chamber of Commerce is rooted in holistic community and economic development in which advances economic opportunity and growth, innovation, and comprehensive business planning for the Bronx. Intro 762 will help local businesses. Passing this bill is critical to supporting restaurants who need options for delivery, marketing, and advertising. Third-party delivery apps have proven to be valuable to the restaurant industry, allowing these businesses to meet customers where they are or take advantage of new opportunities to increase their revenue. The city's current law undermines the freedom that business should enjoy to choose the best way to make themselves successful through these tools. We badly need reform to help businesses regain this control and support their growth. Unfortunately, the city's existing policies does the opposite, and instead of incentivizes two outcomes, increases customers, costs, or reducing the products and services that restaurants can access. Either result hurt both businesses and workers by reducing sales. Unfortunately, other regulations on food delivery already having this effect. The higher consumer costs that the city other laws have caused have already suffered millions of loss and orders of hundreds of millions of dollars in sales. This not only hurts the bottom line of local businesses, delivery workers, also suffers from loss of work opportunities. Maintaining the status quo with respect to the price control will exacerbate these problems and furthermore undermine the ability to grow their businesses. New York City law presents needless risk with no benefits. While many cities enacted price controls on food delivery in response to the pandemic, almost none still have those laws today. Most of these cities, counties, and states eliminated price controls entirely.
Okay, I'm just going to ask you to wrap up, please, and you can submit your testimony.
It's time for New York City to also make reforms to eliminate risks that are entirely avoidable. If the current law is invalidated...
Okay, I'm sorry, you have to wrap up.
Thank you.
Thank you very much. Okay, next speaker, please. Thank you.
Good afternoon, Chair Menon and committee members. Thank you for the opportunity to speak today. I am Millie Seiler. I'm here to testify on behalf of Sandra Jaquez, owner of Il Sol restaurant in Manhattan and the head of New York State's Latino Restaurant Association. I'm here to support the Intro 762, a local law that establishes exemptions from limits on fees for